What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we are not talking about the Karen Reed trial. We are looking at Brian Kohberger, the case over in Idaho. We've done a case-by-case snapshot on this one already. We will post the link to that in the comments. It's 1 minute, quick overview. We have a full playlist on this case if you're new to it or you just want a little bit of a refresher. But it started out with Brian Kohberger and his team pushing for a speedy trial. They said we didn't get there. They keep saying they need more time. They need more time. The judge has picked a jury trial date. We've moved it a couple times. It is now supposed to start. Jury selection is supposed to start at the end of July, beginning of August with jury selection, and then a 3-month trial, potentially including sentencing if he is convicted. And the defense comes yet again with another reason why they need to continue this trial. The state says enough is enough. Let's take a listen to a big chunk of that hearing. And while the judge doesn't make his decision in the hearing that we're going to listen to now, he gives us a pretty good indication about where he stands on a continuance. That was a bit of a Speedy Gonzalez intro. So we'll just take a beat, slow it down a little bit as we get into this hearing to set the stage for this continuance. The defense throughout the entirety of this litigation has said I almost called them the Commonwealth. The prosecutor's office is not turning over everything in discovery. It's coming out too slow. It's missing items, missing docs. We have to ask our expert, and the experts are telling us that we know these things exist, that they're not giving us even some potentially prosecutorial misconduct or maybe expert misconduct or things going on where they're hiding or destroying or not giving us things that they absolutely have to have. Some accusations have been thrown about. Judge doesn't seem to like those. We also have to remember this is Judge Hippler, the second judge on this trial. Judge seemed a lot more amenable to the defendant's tactics and questions. But because they won a change of venue, which again is a testament to that, they filed that motion. The state didn't want to change venue. The judge agreed with the defense and changed the venue. That also changed the judge. And this judge is anything but laid back. He has his rules. He's going to stick to it. And he feels very comfortable in his judicial discretion. He's very confident in his rulings. He's going to do what he thinks is right. He doesn't really care much about the public perception. If they think, is he being mean? Is he doing this? He's doing what he thinks is right. And the defense can threaten appeal, doing this for the record, Sixth Amendment right to a fair trial. But if he doesn't buy it, he's not going to go down with it. And he's not going to be afraid to use his discretion. And plus, there's already been multiple continuances in this case. But if you're the defense, it's always a good appellate issue to create. If you tell the judge you need more time and he says no, and something comes up in trial to prove more time would have helped you with that, maybe you have an appellate issue there. So it's something sometimes criminal defendants feel like they have to file right before trial. It's like an obligatory motion to continue. This judge also knows that. So the defense is arguing that they don't have enough information. They have a right to more discovery. Brian Kohberger has a right to more discovery. It could be ineffective assistance of counsel if they're not able to get this discovery. There are witnesses who won't necessarily talk to them, and they just create this mountain of things they still need. And the state's going to have a pretty good response to that. Like, come on, this is an objective standard. Let's talk about what you guys have done, how much time you've had, and what you'll be able to present. So we're going to listen to a little chunk of the defense's first argument, the entirety of the state's response, and then the entirety of the defense's rebuttal, because it is their motion. So they have the burden here. That's why the defense gets to go first and last. And then we'll finish with some of the judge's comments.
Case and in the Lockett case, the jury must have the opportunity to consider all evidence that may weigh against the death penalty. And that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't...
And I agree with her. I agree with her. The defendant has the right to all this. They have the right to investigate the red flags, but there has to be a line at some point. You can always say there's more. And to say that, they have the right to look at everything. It's like, yes, everything that's reasonable and related and material and relevant. Not everything under the sun. You don't have a right of a defendant to look at every single book on the planet, right? Because that would technically be anything and everything. And maybe I'll find something that helps me, Judge. I don't know unless I read that book. That's not how it works. So there are these standards, but a good criminal defense attorney, again, we've talked about this a lot, will make it seem like a major problem and the judge has a decision to make. The state has to explain why it's not such a major problem like the defense argues.
Fanciful ideas of what else could we do in this case. There are real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances.
We call that speculative issues, right? There are issues you know about, and then there are issues that might come up. They're handled differently. They can be very legitimate. Sometimes when we talk in civil cases, speculative damages versus damages that are probable that you can actually prove to a reasonable degree of medical certainty or probability are going to occur. But you have to be careful. You can't say, Judge, we don't know. There could be issues coming up. Therefore, we have to continue the case in case any issues come up, right? That's not really how it works. So they've got to dig in and give some more specifics.
And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents.
So another thing she's mentioning, like the court is aware of these. I'm not going to go into specifics. We'll hear from the state that the defense filed a motion ex parte, which they're allowed to do, but it kind of makes the state go in blind and makes it difficult for the state to argue against this. And we'll hear how the judge deals with that.
And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage.
So this is the one that is pretty specific to this case, right? The media coverage and issues that have come up in this case that don't necessarily exist in some of the other cases. That's something that he seriously has to consider, and we know he wasn't happy about based on our last video that we did and the comments that he made and a potential special prosecutor and really finding out who the leak is. So this is really where it's more of an individualized case and not, you can look objectively at this case compared to all the case law and see, have they really had enough time? Do they really have enough information? Are they able to competently represent Brian Kohberger in the guilt and the sentencing phase, potentially, if we get there in this case? That I think is an easier decision versus this one.
The Dateline issue that has been talked about in this courtroom before and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime.
That's not great, right? That's not good. You've got to figure out how to deal with it. I think the state has a good point too, though, on their response that we're going to hear in a second, but that's not good. That's unusual. We got to figure out how to deal with that as a team, as a judge, as a defense lawyer, as a prosecutor. All of us are a team in the effort that we want this to be a fair trial in the media, not to affect this result and not to create an appellate issue.
It's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries, at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time.
Yeah, but that's going to be, no matter when you try this case, you're going to need a lot of time for jury selection.
based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
To allow some space after what's recently happened in the media. Again, very important comment that the state's going to have something to say about.
Of course.
Thank you, Your Honor. I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue.
Always very important. When the standard is on your side, you start with it, right? He's like, what's the standard? What do you actually need to do to continue this case, Judge? Let's look at it from that angle.
As opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant...
So if you deny a continuance, would you be violating the defendant's rights with unfair prejudice by denying it? Objectively speaking, not just subjective, does a defense lawyer think you're doing it? Objectively speaking, are you doing that?
And the counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And Clark needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in...
So it's like, we agree. They have a right to get a lot of stuff, but not everything. Not scorched earth, not every document, not every book, not every expert. It's within reason.
A standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you.
The judge is like, yeah, it's going to be kind of hard for you to know what they put in there since you're not allowed to read it.
What specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, to prepare for trial.
Which I'll just tell you, like, they have. And the bar is so low for all of this, so Ann Taylor can argue whatever she wants, but unfortunately, it's not how it should be. But the bar for reasonable defense and competent defense, they have cleared it. She has done a great job. Her whole defense team has done a great job. They have looked into everything, hired more people than most indigent clients could ever dream of in this case. So there's just no court that's going to find, unless there's some smoking gun she can point to specifically, and that maybe she's filed an ex parte motion. Like, we need this, we need more time for this. Outside of something like that, I don't see this being a big risk to this judge.
There's no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge as the court.
By the way, 56 witnesses and 132 like exhibits, I think he said, for mitigation is a lot. That's what they have in this case. That's an insane number of witnesses and documents, which, hey, great. Put on a good defense. Every defendant deserves it. I'm not going to say it's too many. I'm not going to say they shouldn't have been able to do that. They absolutely should. But at some point, enough is enough, and you got to draw the line, and the judge has to say we're going to trial.
Court has that will pose challenges for jury selection.
Let's not forget, there are victims in this case and victims' families and witnesses in this case that it's hanging over all of their heads too.
Though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be...
I mean, that's a good point. Right? We can't control the media. We can't control what they're going to do, when they're going to do it. We can control what we leak and what information they get. Of course, we should be able to control that in this courtroom, right? But so let's say somebody writes a book every 3 months and the defense wants a 3-month delay after every book is written. Are we just never going to try this case? I actually think the state made a better argument here on the media coverage than I've heard in a while.
That it puts us at the whim of the media. I mentioned with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game. After, by the way, the trial date was used to oppose an extension that we filed for.
He's using this, or saying that Ann Taylor is using it as a sword and a shield, the trial date.
With respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would
And that seems like a vague and not a very eloquent argument, but that's because he doesn't know who it is, what they're arguing, what they're going to say. So it's very difficult because I always tell you guys, what makes me least nervous is being prepared. The more prepared you are, the less nervous you are as a lawyer. You really have nothing to be nervous about if you're prepared. You're going to lose a lot. You're going to win a lot, right? It all sometimes it just depends on which part you are in the case. That shouldn't be something you fear or are scared of. You just don't want to get embarrassed. You don't want to be unprepared. You don't want to be unprofessional. But he can't prepare. And the judge understands that. And I'm glad the judge made that comment. Like, well, how would you know what's in there? It's ex parte. So he's not going to hold it against him. So he's doing his best to try to make these arguments without knowing the full picture, which can be difficult as a lawyer.
Try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust
55, I think he said they added another one, so it's 56. And over 130 exhibits. That's a lot. That's a lot.
55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete, and the experts didn't say we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have life history for the defendant. The defense has amassed significant materials.
It's also not the state's job to say the defense has enough, they've done enough, they should have to stop at all. It's the judge's decision when the defense has told you we don't have enough, we can't do enough. Is she being speculative? Is she saying, we never know what could come up, judge? It's like when I have a client, they're like, I don't want to go to trial right now, or I don't want to settle this case right now. What could happen 10 years from now? And I say, we don't know. What we know is what the doctor puts in the projections based on the science and the research and the data, what you're likely to need, how much you're likely to need in a life care plan or whatever it may be. But you can't just go on in perpetuity forever because you don't know what's going to happen, because that's just always how it is. Right? So that's, I think, what he's trying to get the judge to determine, like, okay, fine. If they get more time, how much more time? You can't base it off of a new docu-series or episode or book, because that could happen again in perpetuity for the rest of time. People could be writing books about this case. So we got to base it off something finite, not speculative, something specific that we know about.
And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
And they get to respond.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records, of Brian Kohberger, past treatment records of Brian Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information.
But again, it's not like it's been 6 months, right? I get it. And it sucks and it's hard and it's impossible and it feels unfair. The state can get witnesses so much easier than the defense in every case, especially a case like this. She's absolutely right. I bet so many people don't want to be involved. Nobody probably wants to help Brian Kohberger. Everybody around there probably thinks he's guilty. It's so unfair. He should be presumed innocent. But she could be saying the same thing 3 years from now, right? People still might not want to be getting involved. And that's why if it was the first trial date and it had only been 6 months, I'd be singing a different tune. The judge would probably be looking at it differently as well. But we're dealing in reality with where we are, what they've been able to do, which is a great job. And hey, I've said this before, good lawyering gets held against good lawyers sometimes. We talked about it with Alan Jackson in the Reed case. And when judge was like, you did a very good cross-examination, so I think you cured that problem. And I think the same thing's probably going to be held against Ann Taylor and her team for doing such a good job that it's like, we can't just keep doing this forever.
Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Brian Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Brian Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court,
In federal court.
which moves at a snail's pace in its best day. In regular cases,
It's super funny because, like, in the civil world, federal court moves so much faster. In the criminal world here, the federal court moves so much faster. Here in the Middle District and in, most Florida courts. Now, some criminal cases in state court, you can move faster, but it's really funny that he said that because here I feel like federal court usually moves faster. But there he said it's at snail's pace. And she said she doesn't practice in federal court. That's interesting to me.
Years into a case, and the expert on the case, this is 2.5 years into a case, and the average for capital cases is 3.5 years.
in federal court,
In federal court.
which moves at a snail's pace in its best day.
So
In regular cases,
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where—
by the way, do you get the way the judge is feeling right now? He's like, it's been 2.5 years here. 3.5 years is a snail's pace. Do you think he wants to move at a snail's pace? I guess is no, if you have listened to this judge before.
we have a client and we need to investigate both the merits phase and a penalty phase at the same time. It takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of
It
it.
could be trauma in the childhood, people admitting it, maybe parents or uncles or aunts didn't know about it. They talk about it. Oh yeah, indication here. So I do get it. It does take time. But again, I feel like it's been a long time.
Family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in—
I wouldn't say it's excessively fast. I wouldn't say it's excessively slow from my perspective, right? It feels like it's been the right amount of time. And again, what really, whether it's 2 years or 3 years or 5 years or 10 years, that doesn't really matter as much. Obviously, if it was 10 years, it would matter more. That doesn't matter as much as why do you need the time? Just saying arbitrarily it's only been 18 months, you can use that argument, but why do you need more time? And that's something we don't know because of the ex parte motion. If there are some very specific, really big things she hasn't been able to do because of time, then I don't know that. And maybe the judge will consider that. But based on what we can see publicly, public facing, seems like they've been able to do a lot in comparison to most cases who their lawyers. So I'll tell you the difference. A lot of cases take 3.5 years because some of the lawyers do nothing on the case for 2 years. Then they start working on it, right? Look at Sarah Boone's case, for example. That lasted a long time because I don't think the lawyers were working every day really hard on the case like Ann Taylor and this team is working for Ryan Kohberger. So each 2.5 years is not created equally.
Having a mitigation expert on board, there was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas
I agree with that. I don't think her team has done anything to add to the delay in this case.
of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
And now's where we're going to get kind of the judge's thoughts. I'm going to slow it down to just normal pace here so we can get what the judge thinks about all this. He's not going to rule from the bench right here, but he's going to give us a pretty good indication of how he's feeling.
All right, I'll take the matter under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for.
I would encourage everyone to continue to work as if the trial is going to take place when it's scheduled to. That's a little wink, wink. That's almost more than a wink, wink. We ain't going to continue it. But what I appreciate about this judge, if he changes his mind and he goes back and he looks at it more and maybe reads the ex parte motion as like, we do need to continue this, he'll make that decision. I have full confidence he will do that. And that'll be no harm, no foul. But what I would hate is if a judge is like, I'm inclined to agree with the defense, but let's wait and see. And he takes a week and now they've wasted a week. If he changes his mind, it's like no continuance. So I'd rather it be on the other side where everybody's still prepping and pushing and doing everything they can to crank through, pull some all-nighters, do what you got to do to get it done. Because if he continues it, then you still have more time. But if he doesn't, at least you are continuing to do everything you could to get this case prepped and ready to go on the trial date that's currently set. So I do appreciate when judges do that, especially this way. I'd rather you tell me it's probably going to go than even if you're going to change your mind rather than the other way around.
In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would.
He's like, I'm not making any guarantees. I reserve the right to make whatever decision I come to.
Write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
He can't be any clearer about where he's leaning in this case, right?
All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the
So when they talk about going into the private section of this hearing, it's because there is, I guess, a hearing about an alternative perpetrator that the defense wants to talk about. And that's obviously private and not something that we get to watch with them. So that's a pretty major bombshell update that we don't know the answer to. And that really, to me, indicates hold on a second here. That indicates to me that even more so, this is going to be a case where during the trial, so much more information is going to come out about things that we do not know. And people think, oh, this is all the evidence. There's not a lot here. It's easy, reasonable doubt, whatever it may be. People have already kind of indicated what they think about this case and what they think about the outcome of this case. And I always say, hold it, hold it, hold it. We don't know everything. We're not the lawyers on the case. Just wait. Because, as it comes out, you may be surprised, presumed innocent, make the state prove it beyond reasonable doubt, all that, right? And that rings true in this case almost more than most because of the gag order, because as things have trickled out and we're getting some breadcrumbs here, breadcrumbs there, inside source, here's a little documentary, here's a book, all these things. And every day it seems like I'm hearing something new on Bryan Kohberger. And the alternative perpetrator, AKA somebody else did this. Who is that somebody else? We don't know. Seems like Bryan Kohberger's team is building on that, and that might be a defense, which would be shocking and something I don't know about. I don't know who he's going to point the finger at. We can maybe guess, but that's not all. There's another major update. Is there another eyewitness that saw Bryan Kohberger at the scene of the crime? Let's take a look at a little video clip here from Court TV.
Conversation was captured on body camera video. Let's take a listen to that.
And then now I have with this make her face here, so yeah, because I'm the DoorDash driver, so yeah. You have to testify in which murder? Murder case with college girl. Oh.
All right, let's.
So, I don't really know fully what to make of that, but she says, I'm the DoorDash driver. And we all know about the DoorDash driver getting there right around the time all this was happening. People thought, could the DoorDash driver have done it? Is that the alternative perpetrator? If the DoorDash driver saw it, did more roommates see it? What did she see? Does she know it's Bryan Kohberger? Did she see the Elantra? Did she see the bushy eyebrows? Does she know who Bryan Kohberger is? When did she say she saw him? What is that police camera footage about? Like, a lot of unanswered questions. But I mean, if they have multiple other eyewitnesses, or if there is a legitimate alternative suspects that does or do have connections with one or more of the victims, which is one of the big weird things in this case, are there more connections we don't know about between Bryan Kohberger and the victims? I just feel like what I'm confident about in this Kohberger case is I don't know everything. I don't know all the facts. The state has been supremely confident for a while. The victim's family, who has not seemed to be in lockstep with the state throughout this entire process, seems to be incredibly confident that it is Bryan Kohberger, that he is the one that did this. Now, we just saw a case in Karen Reed where the O'Keefe family felt very confident and strongly that Karen Reed did it. That's the feeling I get going into this case. The feeling I got going into Karen Reed was a lot of reasonable doubt. The feeling I have going into this one is a lot we don't know. You guys tell me, what is the feeling you have going into this Bryan Kohberger case? Let me know what questions you have. Let me know if there are other documents or hearings specifically you want to talk about. And if this is a trial you guys are going to want us to follow and continue to talk about in this case. So far, I would say this has been the most requested case to jump back on post Karen Reed. But you guys let me know what else you're watching, what else you're interested in. And that will drive the content we talk about on this channel so we can learn together. So that's all I got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.